we are talking today about wills and trusts and differences between those two documents and when you would want to use one versus another. Just a reminder, if you're participating via Zoom, you can ask questions as I'm going through. So if you see the little Q&A function, there's a place for you to fill out or submit questions, and I'll see them pop up and I'll try to answer them as I go through. If for whatever reason you don't feel comfortable asking questions or you want to just set up a meeting later, there is an evaluation form you'll receive after this that gives you a place to fill out that you would like to set up an initial consultation with our office. Those are complimentary. They're usually scheduled for about 2 hours. They don't necessarily need to take 2 hours if you, for some reason, don't have 2 hours that day, but we set aside that amount of time because it gives us time to get to know you a little bit and figure out what plan might be right for somebody or how to best deal with your questions. So, another little, housekeeping item is you'll be getting, if you signed up in advance, you'll be getting a document finder from us. Our document finder is essentially, where am I keeping my documents? It's a little grid that says, all right, I have powers of attorney or I have a will, and here's where I'm keeping it, so that you can have your family members or your agents or the trustees of your trust, for example, find the documents when they need them. To get started, I guess, the big question we get when someone comes in and talks to us is, what do I've heard about wills or trusts, or I think I just need a will, or I think I need a trust, but somebody doesn't really understand what they're used for, or why you might use one over another. So most people are familiar or have heard of the term probate, for example. Probate is the court process in which someone's estate is divided up amongst beneficiaries, in which debts are paid, creditors are able to come forward, make claims, things like that. And probate occurs if you have no plan at all, for example. So maybe I never set up a will or I never set up a trust and I just kind of passed away with nothing in place. That could be when probate occurs, but it can also occur when someone has a will too. So a big misconception that people have is, if I have a will, my estate will avoid probate because I have a will, and probate's only for people without any sort of estate planning documents. But wills are actually specifically instructions to the probate court of how you want your estate handled. So that can lead to a couple of different issues for people. One, if that's not what they were anticipating their plan being, that means the kind of result is going to come as a shock to the family or to the surviving spouse, for example. Another is, if someone has a will, and because wills only control what go through probate, a lot of times what happens is people have specific beneficiary designations on their accounts. So, on a life insurance policy or on an IRA or, a bank account, for example, it's payable on death or transfer on death, you might see. So POD or TOD is another acronym that you have to keep your eye out for on those accounts, of course. But that's what we would kind of in general refer to as a beneficiary designation. And those pay directly to the individual that is listed there, or the organization, if it's like a charitable organization. They do not go through probate. So the big problem somebody might have when they have a will is if they're expecting the provisions of that will to be followed, and maybe they only left one account to maybe the person who's acting as the personal representative or the executor for the estate. Well, that person's now the beneficiary. They are under no obligation to follow the terms of the will with that account. So it can lead to some confusion when people are setting up their estate plans, but it can also not, the end results that you're intending to occur may not if you don't have your plan properly aligned. So I've talked a little bit about what probate is, but people often hear about why, how it's bad or why they would want to avoid it. And generally what you're hearing people talk about is the length of time it takes. Probate on average can take, about a year to a year and a half. And that's not uncommon at all. Part of it is there's a lot of kind of hurry up and wait on the part of the estate and the personal representative side. It's make this filing by the state and then, wait for the next thing to occur. So it's, it's a lengthy process. It's not going to be over in a couple of weeks. That would be probably the world's fastest probate if that had ever occurred. But I mean, just in terms of some of the waiting periods alone, it's going to be a couple months, at least 6 months. But that would be incredibly fast, obviously. So probate then is lengthy. It's often very expensive for someone's estate. So probate, the cost of probate is going to range, of course, on a variety of factors, things like complexity of the estate, possibly the amount of money going through probate, and also attorneys' fees vary by attorneys, right? They're not all the same across the board. We don't have like an agreement amongst all attorneys in Wisconsin that we're all going to charge this rate, right? So those fees vary a lot too, but an average of what you'll see is kind of 3 to 5% of the value of someone's probate estate. So to give you an idea, so if somebody had $1 million estate, which is not at all uncommon these days, if somebody had that size of an estate going through probate, it could cost $30,000, right? And that's not nothing. That's quite a bit. So it's expensive. The other problem that people have with probate is often the fact that it's not an immediate start to it, right? So what I mean by that is just being named as someone's personal representative or as their executor in a will doesn't just give you automatic authority to go and start acting. You have to first be approved by the court, which requires you to submit the will to probate. If you don't do that, you're not just going to be able to go down to the bank, for example, and say, look, I'm in my mom or my dad's will. I'm the person who can do this. They'll say, who cares? Show me what's called a domiciliary letter, which you have to be given by the court first. So those are some reasons that probate can be, not great for people if that was not their intention. But there are perfectly valid reasons to use probate as well. I mean, as with anything, there's never a this is always right or this is always wrong situation. It's the classic lawyer, it depends. And when you would need to go through probate, at least part of the process using probate for this would be if you have minor children, for example. You have to name guardians for children in a will. That's where that designation occurs. So you couldn't just write on a slip of paper that these are the guardians and then that's somehow legally what happens, or one time I saw it put into someone's trust. Obviously, we did not do this plan for them. This was a prior plan that came in, but you can't name guardians in a trust because the court is the one that has to approve that. They have the best interest of the child at heart and things like that, and they have a legal obligation to make sure that the person is fit for that role. So if you have minor children and you intend to name guardians for them, which should, you have to do that in a will. So that doesn't mean someone with minor children, all the money has to go through probate necessarily. They might still have a trust as well. But where that estate will use probate then is if those guardians are needed, if the kids are still minors at that point when the parents pass. So that's a really big reason and probably the most common reason that anybody would really need to use probate. Another is if, for example, someone has what's called a deficit estate. So a deficit estate is when somebody has more debt than they have assets. So they owe more than they have in the bank, right? Or in any of their investments or their assets combined. That is when you actually may want to use probate, because this is when you don't have enough money to satisfy the creditors, right? There's not enough in the estate to make sure everyone gets paid what they're owed legally, and then there's anything left over at all. So where the court comes into that is it functions sort of like a bankruptcy proceeding then, where the creditors may not all get paid in full. They may get paid in terms of their priority or in terms of a proportionate amount based on things, but they may not get paid in full, and some may not get paid at all. But this is where probate can be very useful, because then you have the court signing off and saying, yep, these claims, they're paid as much as they can be, but there's nothing beyond that. So other creditors, you have to go away. You can't keep coming up against the estate anymore. A common misconception is that the personal representative or maybe the beneficiaries owe those creditors at that point. And in Wisconsin anyway, the answer is that's not true unless they co-signed on any of these loans. That kind of thing can still happen, I suppose, but that's another reason to use probate, is to make sure there's a court overseeing all of that too, if you do have a deficit estate. Another, a little more, I guess, probably a little more niche use for probate, not applying kind of across the board by any means, but there are certain types of trusts for beneficiaries that can actually only be set up using a will. It's what they call a testamentary trust. So there are certain long-term care planning mechanisms that spouses might use for one another, for example, to help protect assets for the surviving spouse so that it doesn't have to be spent down on their care. That you have to put in a will under Wisconsin's Medicaid's rules. So that is one reason that you might also need to use some level of probate intentionally. But if the goal that you have for your estate is to avoid probate, people often then use beneficiary designations, especially if they haven't really talked to an estate planning attorney in a long time, or they maybe had a will drawn up when their kids were young, but now their kids are all grown adults. They might have gotten advice from somebody at the bank or, a friend, or, they read it online that if you want to avoid probate, put beneficiary designations on everything and put payable on death and transfer on death on your accounts. And then you don't even have to worry about it. But the problem with only using those in relying on them as the plan is that they're really tools to be used in a plan, but they are not an overall cohesive plan by themselves. There's a lot that can go wrong if you're overly relying on beneficiary designations and not some other planning document as well. So I mentioned already that if you have a will, your only control from that will is if an asset is going through the probate process. So if your beneficiary designations do not align with your will or do not send things to certain assets through the probate process, your will isn't going to do you any good. So you kind of have two documents in conflict there. Another problem with beneficiary designations by themselves is that it's not a central controlling plan. It's on each account has its own thing. And you have to be aware of what the company's sort of contingents are. So like if one of these beneficiary passes away, what does that share go to? Does it go to their kids? Does it just lapse and go to the other beneficiaries? I mean, these are things that you need to be aware of then if you're relying on those. And another really common issue is what happens if you have beneficiary designations on an account, but then, at the bank, but then the bank gets bought out. Did those transfer over to the new bank account at the new like credit union, for example? Or did that, when that transfer of ownership occurred of that bank, did they not do it correctly? Did they change the beneficiaries or completely forget to put them on the account? That's a really common thing that comes up is when ownership of an account, or not ownership, but like the ownership of the institution changes, is maybe they didn't, the records didn't transfer over right. And that can create problems too if you're thinking, hey, those were still fine when last I checked, but it's been 20 years. You might not have the right beneficiaries there anymore. Which is one of the reasons it's also a really good idea, regardless of what type of estate plan you have, to check on those beneficiary designations every 5 years or so, just to double check and make sure that everything's still in alignment. And that's a big thing that we talk to our own clients about too. So it's kind of all over the place. They don't give you that central controlling document where people can go to one place and figure out, okay, here's what I do. Here's how things get split up. They have to go to every institution. A big concern with beneficiary designations by themselves is if you have it going directly to somebody, that money becomes theirs, right? They become the owner of those funds upon your death. So this is where if you are expecting final expenses to be paid by your estate, like final funeral costs maybe, or final medical expenses, even the most on top of your debt payments and things like that, the most responsible people in the world, there's usually always like some sort of like final hospital bill for somebody that I see. So there's always something, even if you are the most responsible and kind of on top of things person in the world. But if you're expecting those expenses to be paid by the estate, well, if those beneficiary designations, if that's where all of the money went, it all went to those people, is the personal representative able to pay those expenses? Or is the personal representative even one of those beneficiaries? Where does that money come from? So you want some amount of money to be available to the person administering the estate as that administrator, not as the beneficiary, because you don't want them to personally have to use that what you expected their inheritance to be for debt either. You want that to all come out first. So, before people split up their inheritance, so everyone sort of shares in those expenses equally. And what I mean by that is, if you said, I want 50% to one son and 50% to the other, and then what son one was the personal representative, and he used some of his share to pay for the creditors. Well, what if there's not enough money in the estate to reimburse him fully? Then he didn't get 50% like you intended. He got less, and that's not what you wanted. So it can disrupt the planning. But another thing that can happen when money just goes to somebody is anything that happens to them as individuals also happens to the assets they inherit, right? If it's just in their own name. So what I mean by that is, what happens if one of the beneficiaries is receiving any sort of like means-based assistance from like a government program, whether that's because they are disabled, or maybe they're on Medicaid because they're older and they're in a nursing home. Or maybe they're a child with special needs who has some sort of government program that is really important to them, right? And it's not necessarily the monetary side of it, but maybe the actual program itself, that kind of they have like a caretaker or something like that that's really essential to them. Well, if those are means-based programs and that person just receives an influx of money, that can cause problems, because now they're over the amount they're allowed to have. That can disrupt those benefits. But it's not just benefits either where this can be a problem. It's also things like if someone is in the middle of a bankruptcy, or they get divorced at some point, or they get sued, right? That money is available for those things potentially. And if somebody inherits in the middle of a bankruptcy, right, they cannot just go hide that money. That's what the bankruptcy court would call a fraudulent conveyance. They can't just give it away to protect it. So they have to use it on that debt potentially, if they themselves are just an outright beneficiary on an account like that. Inheritances are not generally considered marital property in Wisconsin. However, why they often divorce can be a concern is people tend to put them in joint accounts sometimes, and then that's where it's really difficult to figure out what is marital property and what isn't. And it can just be really difficult to deal with at that point. So it does potentially put it at risk when you do that. So if those are the concerns you might have for your beneficiaries, or could potentially be a concern, you don't want just to outright leave it to them without a separate plan in place to say, okay, here's what happens if any of our beneficiaries have liabilities going on at the time, or maybe they have a substance abuse concern. You don't want them to be in control of the money. There's no way to limit the control of the estate in how they use those funds once it's theirs, right? You can't tell them what to do anymore. So if they have a substance abuse concern and they're a beneficiary, well, that just means they can use it on that problem that they have, their substance abuse. And that isn't what anybody would want, because it's harmful to themselves. So that doesn't mean, though, that you have to just disinherit these people. You don't have to disinherit a child with special needs, or someone on benefits, or someone who has a substance abuse issue, or maybe just a responsibility issue, right? Maybe they're just not good with money. There are better ways to leave them assets that do not cause them those same issues, but they require you to coordinate those assets with your will or your trust, because those are the documents that are going to be able to set those up, those types of protections for them. So you don't want to have a will and have everything avoid the will, and therefore not use any of the protections built into it. But if your goal is to avoid probate still, that's where trusts tend to come in. A revocable trust is probably the most common one that people hear about. That, or like it's often referred to as a living trust. I mean, a living trust is more often than not just referring to a trust that was created during someone's lifetime, right? But often people mean the revocable kind when they're talking about it. So a revocable trust is mainly used when someone wants to avoid probate, but they want to have their estate controlled by one thing, one document when they pass, where everything flows through that. And if there's any concerns for beneficiaries, or like liabilities for any of those beneficiaries, or there's something else going on in their life that means they just shouldn't inherit as themselves as individuals, well, that trust can then say, well, we're going to set up a protected share for them. It's essentially a trust fund that you might have heard about. And no, they're not just for the wealthy. Trust funds are really useful tools where they're asset protected and they can be controlled in terms of usage and what age someone might have to be before they can be in charge, so that you can protect the assets for them. We often refer to it as sort of protecting people sometimes from themselves and other times from kind of the outside world, from everyone else. So, just because someone is 18, for example, too, I mentioned age, you don't necessarily want an 18-year-old to be in charge of potentially a couple $100,000, right? You want them to have that guidance first. I don't know of many 18-year-olds that would generally know to spend that money wisely or invest it, or not just go out and, go, oh my gosh, this is more money than I've ever seen, something like that. So, you can put an age restriction using one of these sort of asset protected trust shares for them that say, okay, you can't be in charge of it until you're 25 or 30 or whatever age you feel is when they're going to be responsible. And you can tweak that too, that age, as they get older. And if they get closer to that age and you find, I think we should add another 5 years to that because they're still not quite there, right? I mean, these things can change over time. But if you just leave money to an 18-year-old through a beneficiary designation directly, you don't really have the control anymore. And these types of inherited kind of trust funds like this can be very useful too when there's minor children, because minors cannot inherit property legally. They have to be set up in like an UTMA account first, and then a custodial account, which is a custodial account, excuse me, which will then terminate at a certain age where they can have it as their own. But, it's a whole extra step that you have to go through. So with revocable trusts, though, one of the really important things with a revocable trust is kind of like a will only controls what goes through probate. A trust only controls what it owns at the time of someone's passing. So if someone has a revocable trust, but then maybe they only have their home in that trust and all of the bank accounts pay out directly to those individuals, well, you're in the same situation as you were in before, where somebody has this well-crafted plan. Maybe there's a lot of protections in there, but you're completely avoiding it with those beneficiary designations. One of the most common things I see is somebody comes in with a revocable trust, maybe that they had drafted years ago, and maybe the original attorney put the home in. This is pretty common. They put the home in the trust, and then they told their client, go do the funding yourself. Funding meaning like retitling assets. And what more often than not happens, just because it's not something someone's used to doing, like titling things in the name of the trust, or it's a lot of work to do on the client's end, they just never end up getting around to it. And the trust never ends up being fully funded, or it's not funded correctly. And that is, you're in the same situation, right? Whether you have a will you're not using because you're not going through probate, or you have a trust you're not using because it's not funded properly, well, you end up in a situation where you have a very, very expensive and fancy piece of paper or collection of papers that may or may not actually, do anything for you. If they're not funded or they're not being used, whether it's probate or like trust administration, if you're not aligning those things with your documents properly, that can create a lot of problems for you. And it just means your plan won't be followed. So if you have all these, really well intentioned goals in a plan, like protecting a minor or protecting someone with substance abuse concerns sort of from spending the money on those issues, and having someone take care of the money for them and use it for their benefit. Well, if you have it go directly to that person again, you're not in that situation. You're not having the plan actually function the way you intended. And like I said, a common misconception when beneficiaries do have these concerns, because people are so used to using just beneficiary designations, is they tend to think, oh, well, unfortunately, I have to disinherit that kid, right? Unfortunately, I can't leave things to them anymore. And that's just not, like I mentioned, it's just not true. There's better planning you can do for them where you're really protecting that person, but still providing for them. You're not just saying, I'm sorry, you don't get anything because of your circumstances. You're saying, I'm providing for you, just this is how it has to be done in order to protect you or protect you from others. And that's okay. And this type of planning, this protection planning, can be incredibly valuable for even the most responsible people in the world, right? There are plenty of reasons somebody might end up in a bankruptcy. Maybe they went into business and the business failed. And they did everything they could, but it just, sometimes that happens. A lot of businesses fail. Whether maybe they're a high liability or in a high liability career, right? Attorneys for one, doctors, physicians, anything where you have a lot of potential liability if something either goes wrong or someone just decides to sue you, or whatever it might be. There's more at risk then. So there's a lot of things that you can do through that protection that will protect everybody, whether you have current concerns or those concerns could come up in the future. It's really not something that you want to leave up to chance. The most common thing I hear, probably, and kind of as a rebuttal to doing planning at all, is, well, my parents just did beneficiary designations and it worked out for them, so that's what I'm going to do, because nothing went wrong. And I kind of have to respond to that saying, well, I'm glad nothing went wrong, but I wouldn't necessarily use that as evidence going forward that nothing ever will. We can only plan for what we know now, that's true, but you can also set up contingency protections in either a will or a trust to use it. So what it really comes down to is not how much money someone has, or what their family situation really is, or I guess how they hold their money, even, although sometimes that can play a factor. It's really not the money side of things that matters. It's really what's going on with your family, what kind of protections are they going to need, and what process do you intend to use or for your estate to use, I should say, after you pass away. What is the end goal here? Are we trying to use probate, or are we trying to avoid probate? And if you're trying to use probate, a will is just fine. The only thing that's going to actually direct assets in probate is a will. Otherwise, you're stuck with the the default state statutes, which I wouldn't recommend anyone use. But if you're trying to avoid probate, that's where a trust is much more beneficial to you, because that still gives you a central controlling document, where you have sort of the gatekeeper, you have someone in charge. I guess I'm running short on time here a little bit, but one of the last things I'll mention too is one of the huge benefits of a trust over a will, or I guess there's a couple of key ones too that don't have to deal with just what process you're using, but one is privacy. So what a lot of people don't understand or are unaware of is probate is public record. Anybody can go request information on someone's probate estate, which is especially concerning if there's any sort of minor children involved, that you don't want sort of the quote unquote investors to come, try to say, oh, let me tell you how to invest that money in my product or in this fund, something like that. You want them to be protected from that. So privacy is a big concern. Trusts are not public information. They're privately administered. Another is, I mentioned, it can take some time for personal representatives to first be approved. Things kind of get frozen for a little bit while they're being approved by the court. With a trust, that doesn't happen. You pick your trustees, your successor trustees with a trust. So you've already approved those people. When you pass away, the trust says they become the acting trustee. So the accounts never get frozen when someone passes away with a trust, because the trust is still there. It didn't die. So there's no freezing of those accounts. It can be a much more immediate, okay, I can pay bills, I can pay funeral expenses, things like that. There's money available. So one last thing I'll mention is we do our topic next week on June 9th, next Wednesday, is legal changes and updating your plan. So what we're going to be talking about primarily is, when you need to be aware of legal changes, or do you need to update your plan because of those legal changes? And we'll talk about some specific examples of those legal changes that have occurred over the last 10 years or so too, or maybe more, maybe longer, to give you an idea specifically of kind of, why these can impact somebody's planning if you don't update the plan. And just another reminder, we do have that evaluation survey form for you to fill out. If you do want us to reach out to you to set up an initial consultation to talk about any of this further, or more specifically about your family and your situation, please fill that out. You can mark down that you'd like us to reach out to you, and we won't reach out to you if you don't, but it will be much quicker if we do have do have you fill that out on there so then we know to reach out to you. Otherwise, if you want to reach out to us, that's fine too. But please fill that out if you would like to. And I guess with that, I will, I don't see any questions, so I will let you guys go enjoy the nice weather outside, and I hope to see you